trace the growth and development of administrative law in India. Administrative law in India has developed gradually with the expansion of governmental functions and the increasing responsibilities of the state. During the British period, administrative powers were exercised mainly to maintain law and order and collect revenue. However, after independence, the adoption of the constitution and the establishment of a democratic welfare state led to the rapid growth of administrative law. Today, administrative law is one of the most significant branches of public law. It regulates the powers and functions of administrative authorities, ensures accountability in public administration, and protects citizens against arbitrary exercise of governmental power through constitutional remedies and judicial review. Legal provisions. The development of administrative law in India is founded upon Articles 12 and 13, which is for definition of a state and judicial review of laws. Article 14 for equality before law and prohibition of arbitrariness. Article 19 for protection of fundamental freedoms. Article 21 protection of life and personal liberty. Article 32 constitutional remedies before the Supreme Court. Article 226 and 227 for writ jurisdiction and supervisory jurisdiction of high courts. Article 309 and 323 public services and administrative tribunals. Article 323A administrative tribunals and Article 323B tribunals for other specified matters. Principles of natural justice and delegated legislation and judicial review. Let's look at essential features or contents of the development. The growth and development of administrative law in India may be studied under the following heads. First, administrative system during British rule. Second, administrative law before independence. Third, constitutional framework after independence. Fourth, emergence of the welfare state. Fifth, growth of delegated legislation. Sixth, administrative tribunals. Seventh, judicial review under the constitution. Eighth, contemporary development of administrative law. Let's explain everything. First, administrative system during British rule. The foundations of administrative law in India were laid during British rule. The British administration established a centralized bureaucratic system primarily for maintaining law and order, collecting revenue, and ensuring efficient governance of the colony. Various departments and public authorities were created to administer taxation, police, railways, irrigation, and public works. Although the concept of administrative law was not fully developed, these administrative institutions formed the basis of the modern administrative system in India. However, administrative authorities enjoyed wide discretionary powers and judicial control over administration was comparatively limited. Second, administrative law before independence. Before independence, administrative law in India largely followed English legal principles. The administration functioned under colonial statutes and executive orders issued by the British government. Administrative agencies gradually expanded due to industrial development, public welfare measures, and economic regulation. Nevertheless, the absence of a written constitution and enforceable fundamental rights limited the protection available against arbitrary administrative action. The scope of administrative law remained relatively narrow because the colonial government primarily focused on maintaining imperial control rather than promoting social welfare. Third, constitutional framework after independence. The adoption of the Constitution of India in 1950 marked a turning point in the development of administrative law. The Constitution established India as a democratic republic governed by the rule of law and guaranteed fundamental rights to every citizen. It imposed constitutional limitations on administrative authorities and empowered the Supreme Court and High Courts to protect citizens against illegal administrative action. Constitutional provisions relating to equality, liberty, natural justice, and judicial review transformed administrative law into an effective instrument for ensuring accountable and lawful administration. Emergence of welfare state. After independence, India adopted the concept of a welfare state. The directive principles of state policy encouraged the government to promote social justice, economic development, public health, education, labor welfare, and social security. As governmental responsibilities expanded, numerous administrative departments, statutory authorities, corporations, commissions, and regulatory bodies were established to implement welfare policies. The rapid expansion of administrative functions considerably enlarged the scope of administrative law, making it an essential component of modern governance. Growth of delegated legislation. With the increasing complexity of administration, parliament and state legislatures found it difficult to enact detailed legislation on every subject. Consequently, they delegated rule-making powers to administrative authorities to frame rules, regulations, notifications, orders, schemes, and by laws necessary for implementing legislative policies. Delegated legislation has become an indispensable feature of modern administration. Administrative law regulates the exercise of delegated powers and ensures that subordinate legislation remains within the limits prescribed by the parent statute and the Constitution. Administrative tribunals, the increasing number of disputes relating to public administration led to the establishment of specialized administrative tribunals. The 42nd Constitutional Amendment Act 1976 introduced Articles 323A and 323B, providing constitutional recognition to tribunals dealing with service matters and other specialized fields. Administrative tribunals provide speedy, expert, and relative inexpensive justice in matters such as service disputes, taxation, labor relations, and other specialized areas. Administrative law governs their jurisdiction, powers, procedures, and ensures adherence to principles of natural justice. Judicial review under the Constitution. Judicial review is the cornerstone of administrative law in India. The Supreme Court under Article 32 and the High Court under Articles 226 and 227 exercise extensive powers to review administrative actions. Courts may interfere where administrative authorities exceed their jurisdiction, abuse discretionary powers, violate fundamental rights, ignore principles of natural justice, act arbitrarily or unreasonably, or contravene statutory or constitutional provisions. Judicial review acts as the principal safeguard against administrative arbitrariness and ensures adherence to the rule of law. Contemporary development of administrative law in India. Administrative law continues to evolve in response to changing social, economic, and technological developments. Today, it regulates administrative action in diverse fields such as environmental protection, consumer protection, information technology, data governance, competition law, public procurement, digital governance, human rights, public health, and economic regulations. Modern administrative law also incorporates principles such as natural justice, legitimate expectation, proportionality, transparency, accountability, and good governance. Thus, administrative law remains one of the fastest growing branches of Indian public law. Importance or significance: administrative law has become indispensable to democratic governance in India. It regulates administrative authorities, controls delegated powers, protects fundamental rights, and ensures transparency, fairness, and accountability in public administration. It enables the state to perform welfare functions efficiently while safeguarding citizens against arbitrary exercise of administrative power. Conclusion: the government of administrative law in India reflects the transformation of the country from a colonial administrative system to a modern democratic welfare state. The constitution, delegated legislation, administrative tribunals, judicial review, and judicial interpretation have contributed significantly to its development. Today, administrative law serves as an essential mechanism for ensuring lawful, efficient, transparent, and accountable administration in accordance with constitutional values.